background on it, and then.
All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's evidentiary docket. When you hear your name, please say present or here. Bryce Carroll. Jennifer Rollins. Ricky Sanchez. Matthew Gould. Kenneth Nash. Randy Ackerman. Johnny McMinn. Katie Wiggins. Lonnie Austin. Ladari Ward. Ladari DeAnthony Ward. James Weatherford. Katie Williams. Nicholas Fincher. Julie Polens. All right, council, do we have anyone that's ready? We can, but if we want to have her. Yeah, I want to go ahead and administer you to Ms. Wiggins this morning before we call her, please.
Is that the one you're going to approach on?
Mr. Schmidt, you ready?
Yeah, I think we've got it pretty much.
Lonnie Travis Austin, CR 22166. All right, Mr. Austin is set today on the state's motion to adjudicate.
That's correct, Judge. We've been on a continuance for the probation department. The probation officer has been on maternity leave. In the interim, Mr. Austin's had some issues. I've discussed with the state reset. We're going to ask this be reset out for 30 days or the next contested docket.
Any objection from the state?
No objection, Your Honor.
All right, court's going to set Mr. Austin for a final hearing on his motion to adjudicate. I believe the community supervision worker will be back last week of May, so she'll be available for the May 30th at 9 a.m. All right, and Mr. Schmidt, your client needs a report this morning to Ms. Burns. I don't believe that he's been reported. Else is ready?
I'm good. We've got a couple of.
You know, with the big ones. I like that.
All right, let's go forward. This on Mr. Gould.
Yes, sir.
All right, Matthew John Gould, CR 2389.
The Kieran Gould, he just called Gould.
Your Honor, can we approach real quick on this?
Also, we ready to proceed?
Ready?
Yes, sir. All right, this is cause number CR 2389, State of Texas versus Matthew John Gould. This is hearing on the state's motion to adjudicate the guilt of Mr. Gould. Mr. Gould, if you will, I'm going to ask you a few questions. I'm going to swear you in for a limited purpose. If you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So,
Yes.
lower your hand. All right, Mr. Gould, before we move into this contested hearing on your motion to adjudicate, you are represented by your attorney, Mr. Jonathan Manning, correct?
Yes, sir.
Are you pleased with Mr. Manning's representation thus far?
Yes, sir.
You feel like you've had enough time to talk with him about this case? The allegations contained in the motion to adjudicate to the point that you understand what your legal rights are?
Yes, sir.
All right, is there anything that you have not understood up until this point?
Yes, sir.
All right. And Mr. Manning, does your client waive the formal reading of the motion to adjudicate and want to enter his plea at this time?
We do waive and we plead not true to all counts. Taking particular note that I believe state's gonna be abandoning count 3.
Is that correct, Mr. Harlow?
That's correct, Your Honor, in addition to count 1, as those witnesses are not available for testimony today.
So state's abandoning counts 1 and 3?
Yes, Your Honor.
All right, then I'm going to go ahead and get the plea from your client, Mr. Manning. Mr. Gould, as to counts 2 and 4 as contained in the state's amended motion to adjudicate, how do you plead to those counts? True or not true?
Not true.
All right, thank you. Or will enter his plea of not true into the record. All right, Mr. Hartwell, would you like any opening at this time?
State waives opening, Your Honor.
All right, would you like to call a witness?
Yes, Your Honor. State calls Kelly McDowell, Smith County Probation.
All right, Kelly McDowell. Yeah, you'll raise your right hand on the patient. Ma'am, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. Move that chair around. We'll adjust the microphone to you once you stick it on. During your testimony today, it's important that you speak up loudly and clearly so we all hear you. Do your best to speak one at a time, allowing the attorneys to finish their question before you give an answer. A lot of times witnesses want to go ahead and start offering the answer because they understand the question. Resist that urge, allow them to finish their question so that the court reporters don't have a difficult time typing down what you say and they say at the same time, okay?
Yes, sir.
And due to our proximity to the highway here, it's very likely that we'll hear an emergency vehicle or a loud truck. If there's something that happens that's going to make it difficult for people to hear you, then just stop testifying and move forward, okay? And then lastly, if there's an objection raised in your testimony, just stop testifying. Let the court rule on that and then we proceed, all right? All right. Mr. Hartwell.
Thank you, Your Honor. Good morning, Officer McDowell. Can you tell me what it is that you do for a living?
I'm over the sex offender caseload over in Smith County Probation.
And how long have you been over the sex offender caseload?
I started training back in July of 23 and officially took it over August of 23.
And in your role as the sex offender probation officer, have you come to know Matthew Gould?
Yes, I have.
Do you see him in the courtroom today?
Yes, I do.
Can you describe what he's wearing and where he's seated?
He's seated to the left side and wearing a black t-shirt and blue jeans.
Your Honor, may the record reflect this witness has identified the probationer, Mr. Gould?
Record will reflect that this witness has identified the defendant and probationer in this case, Mr. Matthew John Gould.
Officer McDowell, when did Mr. Gould come under your caseload?
I would say August 1st, 2023 is when the sex offender caseload was transferred to me.
And As part of your supervision, can you tell me what condition S of his conditions of probation was?
I cannot answer that because I do not have his conditions in front of me.
If you were able to review the conditions, would that refresh your memory?
Yes.
And Your Honor, if I could have just a moment. And Your Honor, may I approach the witness?
You may.
So do you recognize document that I handed?
Yes, I do.
And what is that document?
It is Mr. Gould's conditions of probation.
And going to condition S, if you have a chance to review that, does that refresh your memory?
Yes, it does.
And are you familiar with remote comm?
Yes, I am.
What is remote comm?
Remote comm is a software that certain defendants are ordered to have on their electronic device to monitor what they're viewing.
Was Mr. Gold ordered to have remote comm?
Yes, he was.
And how does remote comm monitoring work?
Typically, when a defendant is ordered remote comm, they have to sign an agreement with remote comm, and that's sent to remote comm, and then they're set up to have an appointment set for the software to be placed on the electronic device that they use on a daily basis.
So it's a subscription service.
Yes,
And do you know, is that a month-to-month subscription, annual? How do you know how the subscription works?
it's typically a month to month.
And does it cost anything?
It does, yes.
And do you know if Mr. Gold was consistent with remote comm? Was there any point where he was not on it?
Yes, there was a point where he was unable to pay his fees and his account had been closed.
And do you remember the date for that or the month for that?
I believe it was around November of 2023.
Uh, so November, would it possibly be October?
May I look at my notes?
If they would refresh your memory.
Or after she refreshes your recollection, I just like an opportunity to review the notes that witness that's right from.
Yes, sir.
Okay, yes, it was on. Oh, I'm sorry.
Let me see that before.
Sure. Okay. My notes state that it was on or about October the 27th that Mr. Gould's remote comm account was closed due to non-payment. And then his account was reactivated on November 27th of 2023.
And, so October 27th, and I assume that would have been 2023.
Correct.
And, are you aware of, any reason that Mr. Gold would have been able to afford that, any discrepancy in not being able to afford it versus, choosing other priorities?
Well, I know he was having a hard time during that period. He was trying to pay for multiple things, Lifesaver and he was saying he was trying to make payments on his Van Zandt County fees. But he was still delinquent on his Van Zandt County fees at that time.
Do you know of any frivolous spending, new cars, new tattoos, anything like that?
Actually, on a leading.
Overruled.
To my knowledge, the tattoos didn't come about until later. I have documentation that that was later around December of 2023.
Your Honor, may we approach?
All right, Mr. Gould, the state of Texas has informed the court that it's withdrawing its motion to adjudicate guilt in the case. That means that this motion, based on the oral motion, is hereby dismissed. And that does not mean that you're discharged from probation. It just means that that motion alleging violations is dismissed. So you're going to return to probation status without that motion to adjudicate. You're still on probation, you still have to do all, you still have to abide by all of the conditions of your community supervision. Do you have any questions?
No, sir.
Court's going to direct not incur any additional costs for the filing of this motion through attorney fees.
Thank you, Judge.
So, Mr. Gould, you're dismissed at this time. I would instruct you to go check in with your probation officer today or check in with the probation officers here before you leave. All right, so you're free to go. Mr. White, go approach. Vice Carroll. All right, Mr. Carroll, this is cause number CR 21-208. State has filed a motion to adjudicate or revoke in your case, and I believe today we were set to determine if the court's inquiring as to whether or not you have an attorney that's going to represent you. Are you going to hire an attorney?
Yes, I've hired an attorney.
You have hired an attorney?
Yes, sir.
Who have you hired?
Jeff White.
Mr. White's here in the courtroom and he says you've not hired him. Have you paid him money? No. Okay, then let me give you an instruction on how hiring works. Hiring means I'm asking you to do something for money and you give me the money and now we have a contractual relationship. If you don't give somebody money, you haven't hired them. So you haven't hired Mr. White, correct? You haven't given him money to have him be here to make an announcement on your case and represent you. Is that correct?
Correct.
When are you going to do that? Or are you going to do that?
I am going to do that.
I can't hear you.
I am going to do that. I haven't talked to him, so I haven't.
You haven't talked, if you haven't talked to him and you haven't given him money, why are you under the impression that you hired him?
How is he here?
How is he here? He may be here on another case. I don't know. You tell me how he's here. He's here representing Miss Julie Polans today because Miss Polans has hired him, retained him, and given him money. That's how he's here. So I don't care who you hire. I just need to know, are you going to hire somebody?
Yes, I'm hired an attorney
Okay, when are you going to do that?
as soon as possible.
Can you, today?
Yes,
You can do that today?
yes, sir.
All right, then I'm gonna recall your case at 11 o'clock. So we'll give you an hour to go get someone hired.
All right,
Okay, go ahead and have a seat. Well, you're free to leave until 11.
all
Right.
right, thank you.
All right, this is cause number CR 15-1-123, State versus Katie Lynn Wiggins. on the motion to revoke. Ms. Wiggins, the court is going to set you for a final hearing on your motion to revoke or adjudicate. We're gonna set that for June 20th. All right, that's gonna give the state an opportunity to have Ms. Huber back as your probation officer to be able to testify during the hearing. And that will be your final hearing on that date. That'll be at 9 a.m. For the record, Ms. Wiggins was drug tested and is negative.
She has signed that notice, and it would be excused.
Ready to go, yes, thank you.
Thank you.
Of restitution. Obviously, by all accounts, he's made his decision if he's not in court today.
Okay, Mr. McMahon, come on forward. This is cause number CR 23-61, State of Texas versus Johnny Lee McMahon restitution hearing. All right, go, any announcements from the state?
Your Honor, at this time, the state would move to withdraw the motion for restitution. The victim, Sean Van Dyke, does not appear this morning and we cannot proceed without him.
All right, and Mr. Hernandez, is it a zero restitution or was there an agreed restitution amount or was there zero restitution? Remind me what the judgment was in this case.
Let me have just a moment, Your Honor.
Yes, please.
Your Honor, I've just spoken with Mr. Hartwell and it was zero restitution.
Okay. All right, court finds that on February 13th, 2024, the court entertained the plea agreement between the state and Mr. McMinn. The court found Mr. McMinn guilty of the Class A misdemeanor offense of assault causes bodily injury. The lesser included offense assessed punishment at 9 days confinement in the county jail, gave him credit for 2 days, ordered that restitution would be applied after a restitution hearing, and that the defendant to submit to the Van Zandt County Jail on the day of the plea, serving the remaining jail sentence. The court finds that Mr. McMinn has discharged that sentence. Correct, Mr. McBride?
Yes.
The court finds at this time that a restitution hearing having been requested by the state is hereby withdrawn due to lack of participation by the victim in this case. The court hereby orders restitution, orders a finding that there is no restitution owed by Mr. McMinn. And I would ask the state to prepare an amended judgment reflecting that. Any objection to that, Mr. McBride?
No, Your Honor.
Or you can just submit, the state could just submit a separate order on restitution. And then we can leave this one unaffected. That makes sense. We can just do a restitution order.
Just do it.
Instead of doing the whole judgment again, we'll just do a restitution order and we'll file that as record.
Yes, Your Honor.
All right, Mr. McMahon, you're free to go.
Sir.
You're welcome.
Excuse, Your Honor.
Yes, thank you, Mr. McBride.
Thank you. See y'all.
You ready on someone or you need time?
Ready, Judge.
Yes, sir. This is paid today.
Yeah.
All right, court calls, cause number CR 22-299, State of Texas versus Katie Renee Williams. Ms. Williams, you're fine where you're at. This is a hearing on Ms. Williams' motion to adjudicate. Court finds that the state has filed a motion to withdraw the motion to adjudicate, indicating that there's an agreement between the defendant and the state that Ms. Williams will be continued on community supervision with the condition that she be placed on the intensive supervision, in the intensive supervision program. In addition, that her conditions of community supervision will be amended and modified to include additional report costs, placement on the ISP program, weekly group counseling, and that she will submit to polygraph tests before the completion of the ISP program. Ms. Williams, where you're at, you'll just raise your right hand. Ma'am, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. All right, thank you all again. All right, Ms. Williams. Is this the agreement that you entered into with the state through your attorney, Mr. Schmidt? Right. And you understand what being placed on the intensive supervision program entails? And you've had the advice, Mr. Schmidt, your attorney, throughout this case. Are you pleased with his representation? Like you've had enough time to discuss with him your motion to adjudicate to the point that you understand what's being alleged against you and your rights? And has anybody threatened, forced, or pressured you to enter into this agreement? All right, Mr. Schmidt, do you believe that she's competent to enter into the agreement?
I do.
All right, and probation's in agreement with this, is this correct?
Yes, sir.
All right, then the court will approve the agreement. The court grants the motion to withdraw state's motion to adjudicate. All right, Ms. Williams. There's a warrant active for you, this motion to adjudicate warrant that's being withdrawn today. It's going to take a little time for that paperwork to go through the process out of the sheriff's office to be taken off the system, so you need to be careful. All right, we're going to go ahead and withdraw that, but I want you to come and meet with Ms. Burns before you go. All right, all right, you're free to go. Mr. Schmidt, take those back to you. Ricky Sanchez. Ms. Sanchez, this is cause number CR 16149. Motion to adjudicate. Are you hiring an attorney to represent you?
I am hiring one, but I do not have one hired today's date,
How long will it take you to hire an attorney?
possibly another 2.5 weeks.
If I reset you to May 30th, you're confident that you can come back with an attorney? All right, board's gonna reset Ms. Sanchez for another hearing on May 30th.
Thank you, Judge.
I expect you to be here with an attorney. Okay, giving you more than 2.5 weeks. Remember, just because a motion has been filed does not mean that you are not on probation anymore. You still have to report, you still have to pay. Any violation that occurs between now and your hearing can be incorporated into a motion to adjudicate. So don't throw your hands up and say, they're trying to file on me. Otherwise, it gives them additional things that they can charge you with.
I'm the one that sought this out to get it
Okay,
straightened out.
okay. Deputy Martinez is gonna bring this to you. If you'll sign this, we'll get you out of here. This is clause number CR 23-194, State versus James Carroll Weatherford. Today we're set for a restitution hearing, understanding that the state and defense are both asking the court to reset this matter for June 20th of this year to allow the parties to work on the restitution amount. Yes, sir. Correct, Mr. Hernandez?
That is correct, Your Honor. Thank you.
All right, then the court will, based on the agreement, the court will reset Mr. Weatherford for another hearing regarding restitution on June 20th at 9 a.m.
Uh-oh.
That's great. The rest of it. Go right.
Good. All right, do we have any attorneys that are ready?
Your Honor, Chair, Mr. Nash, status received the court's order.
Mr. Nash, come forward. All right, this is cause number CR 22-71, State of Texas versus Kenneth Ray Nash. The court has considered the post-conviction writ of Mr. Nash. The court has granted the relief requested therein. Court has allowed Mr. Nash to withdraw his guilty plea to the offense of injury to a child. Court finds that Mr. Nash is now placed back on the court's docket for the first degree felony charge of aggravated sexual assault of a child, and the court's going to place Mr. Nash on the court's jury selection docket. Beginning Monday, May 6th. So Mr. Nash, you'll report to the courthouse on the second floor and meet with my staff. Pretrial release officer may also be there. You'll continue to report until your case is reached for trial. And I'm going to consider setting Mr. Nash for a special setting based on the allegations.
Judge, at this point in time, I believe I have heeded my duties and I would ask to be withdrawn from this case. I know that Mr. Nash is looking for representation for that. I'm sure whoever he finds will probably request at least one additional pretrial setting to get all the discovery and make sure that everything's in order for that.
Mr. Nash, are you going to hire an attorney?
Yes, sir. We are talking to friends and family at the moment. We're trying to get the funds together to hire Mr. Manning. If we're not able to do so, then I'll contact the courts for a court-appointed attorney.
All right, so Mr. Manning, at this time, I'm not going to grant your oral motion to withdraw. I'm gonna leave you appointed to Mr. Nash for the time being. If Mr. Nash is able to retain counsel, then the court will then allow you to withdraw. And then if you're hired or someone else is hired, then Mr. Nash will get the representation he chooses. But he's indicated to me that he doesn't know if he's gonna be able to hire an attorney. Because he also said if he can't do it, he's gonna come and ask for a court-appointed attorney.
Yes, Judge. I guess my question is that my understanding of the order as it applies to Mr. Nash's case with very limited representation. I'm going to be providing a bill for that as well. And so I had not provided a bill for that until we had, I guess, been withdrawn, as that was outside of the contractual agreements. So I guess I'd have to go back and look and see on that order of appointment. It appeared it was only for a post-trial motion. And if so, I'd be able to speak to the court about that.
All right, I'm gonna leave you appointed to the case. Go ahead and submit your bill. Mr. Nash, I'm gonna reset you for a status on attorney. You're still to report, you're still set on the court's jury trial docket, Monday, May 6th. You're to come in and report for that. I'm also going to reset you for a status on attorney. I'm gonna give you 30 days to hire an attorney.
Yes, sir.
And I'm gonna have you come back on Tuesday, May 28th at 9 a.m.
Yes, sir.
And if you're gonna be requesting a court-appointed attorney, I'm gonna order you to complete a new affidavit of indigency. And I'm also going to want you to report to the court all of the attorneys that you have spoken with in your attempt to retain them.
Yes, sir.
Prior to that date. You can bring all that information with you on that date.
Yes, sir.
All right. And then Mr. Manning, we'll discuss the invoice payment issue outside of court.
And just also, I guess, I'll be filing a written motion withdrawal based on my understanding. I'll let the court rule on that when it so chooses.
I like that.
Thank you, Judge. Mr. Nash, excuse.
Once he gets the notices of resetting, signs that, then he'll be free to go.
Thank you, Judge.
So those 2 dates were jury selection, May 6th, and status on attorney, May 28th.
Thank you, Judge.
And Mr. Nash, you understand that the court has signed amended conditions of pretrial release that you've signed, correct? And you understand that one of those conditions is you're not to have any unsupervised contact with minors.
Yes, sir.
All right.
Judge, for that jury selection, that's gonna be at 8:30.
Yes, 8:30.
There's Mr. Nash.
Yes, free to go.
Thank you.
We have anyone else that's ready? Mr. White? Who would you like to call first? Ms. Poland, if you'll come forward, cause number CR 22-361.
And Your Honor, may I approach?
Yes. All right, court finds that Ms. Pullins is set for a motion to adjudicate today. The court has received a motion to withdraw that motion to adjudicate signed by the state, indicating that there's an agreement between the state and the defendant, and that the defendant would agree to be placed on the intensive supervision program as a condition of community supervision. Mr. White, is that the agreement you're consummating with the state?
That is true.
All right, and Ms. Pollins, I'm gonna swear you in and ask you a few questions if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Ms. Pollins, you understand that being placed on the intensive supervision program carries with it different conditions of community supervision than were already ordered. Do you understand that?
Yes.
You've taken an opportunity to read over those and understand fully what they are?
Yes.
And you've done so with the assistance and advice of your attorney, Mr. Jeff White, is that correct? Are you pleased with Mr. White's representation? Do you have any questions about this agreement you've made with the state? All right, and state probation is supportive of this agreement?
Yes, Your Honor.
All right, then the court will approve the motion to withdraw the state's motion to adjudicate, place Ms. Pollins back on, continue her on community supervision with placement on the intensive supervision program. All right, Ms. Pollins, you're reinstated back on community supervision and placed in the intensive supervision program. I want you to come over and meet with the probation officer before you leave. After you do that, you're free to go. Is there any amendments? Yeah. All right, Mr. White, you ready, Mr. Fincher?
Yes.
Nicholas Fincher, CR 20-118.
And Your Honor, may I approach?
All right, Mr. Fincher, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Fincher, there is a motion to adjudicate your guilt that's been filed by the state of Texas. Today, they have indicated that there's an agreement in which they would withdraw their motion to adjudicate with your agreement to extend your community supervision for 2 years, and that you be placed on the intensive supervision program until the probation department recommends that you resume a standard probation. Is that your understanding of the plea agreement? Is that what you're asking the court to approve today? And has anybody threatened, forced, or pressured you to any of those agreements? And you've had the assistance of your attorney today, Mr. Jeff White, is that correct? Are you pleased with his representation of you? All right, the court will approve the motion to withdraw. The court hereby dismisses the motion to withdraw. Places Mr. Fincher in the intensive supervision program, extends his community supervision for an additional 2 years. All right, Mr. Fincher, I hope you take advantage of this opportunity that the state's extended to you, that your attorney, Mr. White, has helped negotiate. It seems like it would be, in your best interest to become very compliant, because this is, I love baseball. But this is not a 3-strike court. I don't wait for 3 strikes, all right? So heed what I'm telling you. Don't come back in here and ask for some kind of modification, some kind of grace or something else, all right? This is your shot right here. How old are you? 23. Pretty young to be in here on a felony charge, looking at going to prison. It'd be sad to see that happen. All right, Mr. Fincher, come in and see the probation officers before you leave. You're welcome.
Your Honor, I do have an announcement on Bryce Carroll.
All right, Mr. Carroll, come on forward. This is cause number CR 21-208. All right, so did Mr. Carroll get you retained?
In about 30 minutes.
Excellent. All right, thank you, Mr. Carroll. All right, court's going to reset Mr. Carroll's case to give Mr. White an opportunity to see the allegations and prepare a defense. Mr. White, do you feel 30 days is sufficient time?
It depends on what day it is.
That's a Thursday.
Thursday,
May 30th is a Thursday.
I had a doctor's appointment last week of May. I don't think it's.
Okay. All right, court sets Mr. Carroll for another hearing on his motion to adjudicate May 30th at 9 a.m. All right, you're free to go. Is that all you have, Mr. White?
That is it, Your Honor.
Jennifer Rollins, CR 22-226. All right, Ms. Rollins, a motion to adjudicate has been filed in your case. Are you going to hire an attorney to represent you?
Yes.
Try to call who? Matt Bingham? Do you believe if I reset you for 30 days, that would give you the opportunity to hire Mr. Bingham or anyone else? So what I want you to do is I want you to hire the attorney that you want, but I don't want you to procrastinate. And if you can't get a hold of the attorney that you want, then don't wait till the last minute and then decide, hey, maybe I should call another attorney. Okay. So I'm going to give you 30 days to handle your business, and I expect it to be handled by the time you come back with your attorney. Okay. All right. Court's going to reset Mr. Rollins for Thursday, May 30th. For status on hiring an attorney and motion to adjudicate. Remember, Ms. Rollins, you're still on probation, so you still need to report, do all the things that you're supposed to do. Failure to do that could result in amending the motion and bringing additional charges against you. They're filling out a reset slip. They're gonna bring it to you, sign that, and you're free to go. You're welcome. You're free to go. All right, Ms. Ackerman. All right, Ms. Ackerman, I brought you to court today because you were on conditions of pretrial release. You were placed on those conditions, when you were arrested on the charge of aggravated robbery. And during your period of pretrial release, the, Community Supervision Pretrial Release Department indicated to me that you had, tested positive for THC marijuana. And that would be a violation of your pretrial release and your conditions of bond. That was going to be the purpose of our hearing today. It's come to my attention, the court was unaware and your pretrial release officer was unaware also that the state had rejected your case. So they're not going to prosecute you for this matter, which is going to relieve you of those conditions of pretrial release. So you're free to go. Do you have a copy of the state's rejection letter? Do you have a copy where they've rejected your case and closed your case? You don't? Okay, then you're free to go, but I want you to come over here and see the probation pretrial release department. They're gonna give you a copy of this. You're free to go, okay? And so when she leaves, she's gonna leave out the back. So if you just wanna wait in the hallway, she'll meet you out there. All right, so Richard. All right, court calls cause number CR 21-397, State versus Ladary D'Anthony Ward. Mr. Ward was set for a hearing on his motion to revoke today. Mr. Schmidt, counsel for Mr. Ward, indicated that he believed that Mr. Ward was still incarcerated in Dallas County. However, the court has information that Mr. Ward bonded out on that Dallas County charge on March 22nd with bring them home bail bonds. The court had issued notice to Mr. Ward of this hearing, as well as notice to his bail bondsman, and confirmed that they did in fact receive that. And so the court is issuing a judgment nisi alias capias for Ladary. I believe that does conclude the morning docket. Court's going to stand in adjournment until 1:30. So this afternoon, I'm going to bring over for contested hearings, Mr. Jonathan Lee Lyons, Jose Rodriguez. Is there anyone else that will need to be brought over that you're aware of, Mr. Hartwell? I think those are the only two. If you find out differently, if you'll notify Ms. Tabraham, so that we can make arrangements, because I think what we're going to do is we're going to go ahead and transport those two over here, and then allow Mr. Manning to have his cases called first, so that he can come over and start his contested hearing. We could also, I believe Mr. Lowe only has one on the docket. So Mr. Lowe, we can start with this case first if we need to. All right, court is adjourned until 1:30.